Have you ever wondered why the world works the way it does? Welcome to a journey of endless discovery. This is Explanium.
Since 1925, the Rashtriya Swayamsevak Sangh, or RSS, has grown into India's largest socio-cultural organization. Recently, political leaders have started asking a specific question: why does an entity of this size operate without formal registration under the Societies Registration Act, the Indian Trusts Act, or the Companies Act? This scrutiny has triggered a larger conversation about the rules governing massive voluntary networks and whether they should be legally forced to register. At the core of the issue is a demand for visibility. Critics want clearer financial reporting and stricter regulatory oversight over groups that wield significant public influence. The RSS has a massive nationwide footprint. That scale sets up an immediate conflict between what the public expects from standard corporate entities and how this organization actually functions under the law. Many people assume that if an organization exists in India, it has to be registered. But under Indian law, forming an association is entirely voluntary. As this graphic shows, formal registration is typically sought when a group wants 4 specific legal benefits. Those are limited legal liability, eligibility for government grants, the ability to receive foreign contributions under the FCRA, and the right to own property independently. Because the RSS chooses not to register, it gives up certain rights. Specifically, it cannot legally own property, and it cannot sue in its own name. To manage its physical assets, the organization uses a legal workaround. Properties are held and managed through separate, legally registered trusts, or directly by office bearers acting on behalf of the group. This structure might sound unusual for its size, but Indian courts have consistently validated this arrangement over several decades. Remaining unregistered is a deliberate operational choice. The organization trades standard corporate benefits for a unique, judicially recognized framework. So, without an independent legal identity, how does the government categorize them for taxes? The Income Tax Department officially recognizes the RSS as a body of individuals, or BOI. The BOI classification provides a legal avenue to operate and pay taxes collectively without formal incorporation as a society or company. The organization sustains itself primarily through voluntary annual contributions made by its members, a practice known as Guru Dakshina. Looking at this flowchart, we can see how the courts treat these funds under the principle of mutuality. Money flows from individual members into a central pool, which is then exempt from standard income tax. The reasoning behind this exemption is straightforward. Since the funds are collected strictly from the members themselves and are redirected entirely toward their shared collective objectives, the law does not view the money as commercial, taxable income. Operating without corporate registration doesn't mean bypassing the tax code. It just means utilizing a different set of financial rules, specifically designed for collective entities. This distinct legal standing sits at the center of an intense public debate about how voluntary associations should operate in modern India. Supporters point directly to the Constitution. They argue registration is voluntary by design, and citizens have a protected right to form associations under Article 19(1)(c). They also highlight the track record. The organization has functioned lawfully within this exact framework for nearly a century. Critics counter that scale requires scrutiny. They argue that when an organization achieves nationwide influence, it should be subject to the exact same regulatory checks as a registered NGO or a public charity. Their primary concern is operational tracking. When asset ownership is distributed across various individuals and separate trusts, achieving full financial transparency becomes exceptionally difficult for outside observers. The current argument has moved past the RSS's specific paperwork. It represents a broader tension between the right to free association and the modern public demand for institutional transparency. For ordinary citizens, these legal technicalities don't impact how the RSS functions day to day, but they do raise broader systemic questions about how the law treats different organizations and how large-scale donations are managed. The resolution depends on finding a balance between constitutional freedom of assembly and adequate public accountability. As massive, unregistered organizations continue to grow in influence, the pressure for greater oversight increases. This scrutiny could shape how future governments draft reforms for civil society organizations. Whether lawmakers will actually step in to overhaul these regulations remains an open policy question. For now, the present legal reality is clear. The current framework explicitly permits the RSS to operate without formal registration, as long as it complies with all applicable taxation, public order, and regulatory laws.
Thank you for watching. Subscribe to Explanium today and discover a whole new world of knowledge and understanding.